Very good evening to one and all. Thank you so much for joining and hope you all are in good health. I'm CA Shreya Jain, your host and host for this masterclass, 4 days amazing session. And for this, I'd like to take the opportunity and thank ICI for setting up a specific committee on startups and MSME. The leaders of the ICI, Honorable President CA Nihar Jambusaria sir, and Honorable Vice President CA Devashish Mitra sir, for bringing up the committee and bringing the new changes in the institute. So today is day 4. Since day 1, we have known about building the thesis to more and more deals and valuation. And today, finally, it's about the agreement. And for this, today we have our teachers, our special invitees, eminent speakers, Dr. CA Dr. S. Ravi sir and Abhishek Ravi sir. So to start with, Dr. S. Ravi sir has doctorate in finance and is a practicing chartered accountant, having over 33 years of experience. He holds a diploma in DISA and is an associate member of Association of Certified Fraud Examiners, USA. He's also registered as an insolvency resolution professional. He's the founder and managing partner of Ravi Ranjan and Company, LLP, a CA firm specializing in forensic and insolvency assignments, finance and management, turnaround strategies, business valuations, brand and share valuation, assurance, audit, and taxation. He's the chairman and director of Tourism Finance Corporation of India Limited, also serves on the boards of Aditya Birla Health Insurance Company, and many more. In the past, he has served as the chairman and director of BSE Limited and chairman and director of UTI Trustee Company Private Limited. He's also been on the boards of BHEL, HAL, Union Bank, and LIC Housing Finance, to just name a few. Then we have with us CA Abhishek Ravi, who's a chartered accountant and BSc Honours International Business degree from Brunel University, London. He's a partner at Ravi Ranjan and Co. LLP and responsible for providing audit and tax services to alternative investment funds, also providing advisory services in regards to structuring and setup of alternative investment funds in India, and has successfully set up the Alternative Investment Category 2 Fund, which is focused on deploying in agriculture and allied sectors. Further, he has worked in the field of international taxation and has professional exposure in Indian equity market. So, sirs, we are all intrigued to know, coming to a full circle to the 4th day of the masterclass. The stage is all yours. Please.
So, good evening to everybody. Shreya, thank you for the introduction. I welcome all the participants. It's a pleasure to be invited here along with Abhishek. I welcome him also. So, it's a real privilege on a very topical subject. I know I have seen the 4 days I was seeing the 4 days. I think you've really done a wonderful job of it, because on a particular subject, you have carried out 4 consecutive days of really expert knowledge sharing, which is very, it's a very long and good program. That's what I felt. In fact, when I was told that it's a 2-hour session, I did not know how to take this 2-hour session, because there is so much and there is so much to do, but also on the other hand, it is too long to speak. So, but it's a very, very interesting subject, and it's a very, very subject of the future and subject which has seen history also. So let me tell you this whole topic. The company, how a company, when it's a startup, when it starts its journey, then there are many steps to the journey, and before it becomes a successful company. There is an idea. First, it is born out of an idea, a business. Then it converts into a business model. Then the business model has many ingredients like equity capital, the sweat capital of the promoters, the knowledge of the promoters, the operating team, and then shareholder agreement, and the infusion of capital at various stages, and also who is supporting you, and what is your customer base, what how are you ahead of the curve of the of your competitors. You talk of every startup company. Why, if you see 1 out of 10 companies, why only 1 out of 10 companies are successful? The primarily because there are challenges along the way, and there are many challenges, and how to overcome each one of them is itself a topic by itself. But the fact is, those who have survived that and have gone to the next level, have made a name for themselves, have made good valuations on them, and have prospered very well. But see, I must tell you, if you look at the Indian context of it, you have globally Facebook, you have Apple, which all started as a startup only at some point of time and then grew up to be what they are today. So, similarly, India has seen many such growth stories. We have seen them. And we have seen the journey from a startup to an IPO and more, maybe, and getting investors, marquee investors, global investors. So, it's a process. And this process, the backbone of this whole thing, is an idea. And this idea is converted into a business model. And what holds the business model is a shareholder agreement and the term sheet. Because how much money can a person spend? There is a limitation. You have to raise fund. You have to put in fund. Even if it's your own money, you have to put in fund. There could be multiple people. There could be a technical person. There could be a finance person. So you have all sort of founders who come together and uh, and make a venture out of a idea. So that is what I feel, that the shareholder agreement and the term sheet is a very important topic. And just to again step back, you would have seen the uh, Indigo fiasco today, means about a month ago, 2 months ago. We saw the promoters having uh, 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 disputes amongst themselves, gone to even SEBI. Then today we see Bharat Pay. What happened to Bharat Pay? Today, as late as today, the promoter says, will come out, please put 4,000 crores, I'll go out the table. So we have these type of things. Why does it happen? It happens because there's a mist. So, I mean, why there is a mist? Because there is no clarity. And the clarity is what the shareholder agreement will bring in. The term sheet will bring in. There are instances when the investor has thrown out the founder. And, there are instances, Zop is one of them, where the Birla person, Mr. Birla himself, was thrown out of the company. There are many. iStream is another example where basically the promoter got thrown out and the investors are in. And there are up to a number of examples. And why has this happened? A question for all of us: why has this happened? This has happened primarily because the understanding would not be converted into a, a statement, which was a statement which is called shareholders agreement and term sheet. So, and there are many contents of a shareholder agreement. There are, I have seen shareholder agreement where there are issues of confidentiality. There is an issue of IP, where even a patenting is also a very important aspect of it. Then I have seen shareholder agreement where anti-competition, where you cannot join a competition. So there are various type of facets in a shareholding agreement or shareholders agreement. And I think what is the thing is, whatever you think, whatever is agreed upon in spirit, in thought, is converted into a shareholders agreement. And that is what is the most important aspect, in my view, of viewing this whole thing. And just stepping back again, why are the disputes happening? The disputes are happening because who will bring in capital? Whose idea was it? What will the investor put as terms and conditions? When will I take it to an IPO? What will be my ESOP? How much will I get out of the ESOPs? What will I get as a sweat equity? Many unanswered questions. And if these questions are put in a paper and pencil, in writing, this is very, very important, because it is the fundamental sort of the fundamental balance which we get as we grow. So there are, if you look at again startups and founders, there are companies which have perished within the first 2, 3, 4 years because they can't raise capital, or they have differences between themselves, or the idea has lost the sheen because somebody else has come and caught on the idea and has moved forward. So all these are different various situations, and I think it is very important for the founders and also the investors to simulate what are the problems, what are the good things, and how they can move the company forward. Because ultimately, if the company does well, the startup does well, it's a good valuation, moves on to the next level, keeps ahead of the competitive curve, then you have made it. And finally, you make a successful model out of it. So all this, the backbone of all this is a shareholder agreement and the term sheet. What is a term sheet? Term sheet is a statement given by, or an agreement, not even an agreement. It's a fact or a written sheet where you talk of various conditions of financing, raising money, the percentage, the equity dilution, the sweat equity, everything. So the term sheet could have various things, buyback, etc., etc. So it all depends on the situation. Some have huge cash burns. Some of the companies, some don't have so much cash burns. So it is all very situational, and I think it is very important for the promoters and founders to envisage what they want. And I think this is my take, that if you even look companies which have, for example, Indigo is a long example today. Has established. Bharatpay has been very successful, and after this they have come to this problem. So there are many such instances of people who have failed or who have had disputes because of lack of clarity. And my urge to all the people who are here as participants and to people around, that your agreement has to be very, very correct. Even Facebook had this problem. One of the promoters went off Facebook also. So even so-called Apple had the problem. So everybody had that problem, and we are all learning from this. And I will now leave it to Abhishek Ravi to actually make a presentation. I'll pitch in wherever required, but the fact is, the journey of a company can only be established through proper shareholder agreement. And let me tell you, this shareholder agreement gets converted into a memorandum of understanding, or even memorandum of articles, or a partnership deed in case of a LLP. So all this, that becomes into a legal format. This understanding becomes a formal structure for the company to grow. And it will keep on evolving, because statutory rules and regulations will keep on changing. The ESOP rules, sweat equity rules have changed over a period of time. So you will see the shareholder agreement also goes through the changes. So I think its regulatory compulsions also make the changes in the shareholder agreement. So my take is that we have to be having a shareholder agreement which is basically a thought process clearly laid out, will change with time, will change with regulation, and also will change with the business model. Thank you so much. I will leave it to Abhishek Ravi to take it forward with the presentation and his views.
Good evening, everybody. I'm Abhishek Ravi. Thank you, sir, for the valuable insight. And with that spirit, I would like to take this forward. First of all, Shah, thank you for the kind introduction. It's a privilege to be amongst the industry veteran and sharing the platform with them. Before I begin the presentation, I would like to tell a tale. Tiny Owl, a food delivery business chain, started in 2012, grew at a run rate of 50% in the first 2 years of business. By 2014, it had spread across 11 metros. it had around 600 employees. It raised 23 million from Sequoia Capital, Matrix Partners, and other ACE investors. However, by the end of year 2014, it fired 300 employees. By 2016, it shut down its countrywide operation. When a well-funded company goes through distress and then gets acquired, it becomes a talking point. If alive, it would have been valued at par with Zomato and Swiggy, if not less. What went wrong? Founders infighting, different vision, that of the investor. Of many reasons, the one that has a big role is loosely drafted governance. Amongst them is the shareholder. With that tale, I would like to begin the presentation. Before we deep dive into all the clauses, let us understand the basic terminologies. So the founders agreement, it is between the co-founders and it is signed at the incorporation stage. It generally lists out what are the investments to be made by founders at each and every stage and their responsibilities. Second is the term sheet. It is between the founders and the investors. It is before raising the fund. Essentially, it's an in-principle agreement which relates to the key deal, including the valuation. Term sheet codifies the discussion and includes things the parties have agreed to informally. Third being the shareholders agreement. It is between the shareholders, as the name suggests. It's at the time of onboarding of angel investors or venture capitalists. The shareholder agreement lists out the rights and obligations of the shareholders and how the company will be operated. Moving on to term sheets. As discussed earlier, term sheet is an in-principle agreement and it is between the founders and the investors once they have received a preliminary level of comfort. It's a letter of intent and which has all the proposed terms and conditions. As the term sheet is signed, there will be a due diligence process and parties will negotiate terms, and post that, there will be a definitive agreement. Moving on to the next slide. Let us understand the structure of the term sheet. It generally runs about 1 to 5 pages in length. Most term sheets are pretty standard and have evolved as a market practice over the years. It typically contains information about who the investor is. It identifies the founders, what the pre-money valuation is going to be, also the post-money valuation, the investment amount, whether the investors are going to get a board seat. And of course, in the term sheets, there are a lot of special rights, veto rights and affirmative rights, which we'll be discussing later. Term sheets may vary from transaction to transaction and also depend on the nature of business. Moving on to the next slide. Let us understand the legality of the term sheet. Apart from 2-3 clauses, most of the clauses are non-binding in nature. That is, they're not obligatory. So term sheet creates no contractual obligation on the investor and on the founder, both. Basically, for the founder to accept the investment and the founder to issue shares to the investor. However, there are 2-3 clauses that are binding in nature, which we'll be discussing in the next slide. So let us understand binding or non-binding, whether it is obligatory or not. What makes it binding or non-binding? It is important to understand the intention of the party at the time of signing of the terms and the actions that have been taken post signings. So in other words, it depends on the facts and circumstances of the case. And the facts and circumstances are interpreted as per the Contract Act 1872. Thus, clauses like confidentiality, exclusivity, fee expenses, dispute resolution provisions, etc., are treated as binding in nature. Moving on to affirmative vote. That is also one of the clauses in the term sheet. Affirmative vote basically is a protective right or a veto given to the investor. Affirmative vote means that unless the investor vote in favor of a particular matter, the company cannot take such an action. Generally, these rights are heavily negotiated between the investor and the investee. There's no specific provision or no complete clarity about the treatment. regarding such matters or any legislation in the Companies Act 2013, Security Exchange, Board of India Regulation, or Foreign Direct Investments. It becomes essential for every promoter to ensure during negotiations that every issuance listed in the affirmative rights do not prohibit the company from carrying out those activities, but merely require the promoters to seek approval of the investors to carry out activities. So deep diving into this concept, these affirmative rights are given to the investors essentially does not mean control is given. This has been confirmed by the SEBI Takeover Code and by the order of SEBI Appellate Tribunal, which has stated if an investor is a mere financial investor, then providing affirmative right to such investor do not essentially mean that such an investor is being vested with the control over the company. Let us understand what triggers a founder or an investor to use the affirmative right. It includes the following. It can be a change in the capital structure, change in the charter documents, appointment or removal of the key management personnel. It can be regarding the issuance of share capital. It can be regarding dilution. Furthermore, it can be about suspension to any business activity or removal or appointment of an auditor. So these are the clauses that are the trigger points for an affirmative. Moving on to the next slide, liquidation preference. Liquidation preference essentially means the scenario where either the company gets wound up or sold. The investor will get paid before everyone else a certain amount. Meaning to say that investors should get their money back plus some return before the founders can get anything. They're also known as downside protection clauses or principal protection clauses or a guaranteed IRR. So why are these names given? Is because most of the liquidation preference clauses mention about a 1x return. Even some VCs ask for a 2x return, or some cases where there's a 1x return plus a high IRR. They can be structured in various ways, but the idea is to protect the investor's money. Thus, it becomes like a guaranteed IRR. Moving on. Founders' ownership. Investors don't want to be in a situation where they have funded a company only to find out that one or more founders are quitting or losing commitment soon thereafter and continuing to sit on 50% ownership of the company. The idea is for the founders to be held accountable. The exit clause is an important and interesting one. This clause requires the founders to commit to deliver an exit, either by an IPO or an M&A deal, to the investors by certainty. If that doesn't happen, this clause would typically require the founders to buy back shares held by the investors at a price that delivers a guaranteed IRR, just like a liquidation clause. Many entrepreneurs make the mistake of not giving importance that they would be able to deliver an exit because they think they have time in hand. It's much tougher to deliver a 20% IRR or IPO in 5 years than the investment amount in the next 3 years from the date of investment. So investors often put restriction on the founder's ownership. This works somewhat like a stock option plan where the founder starts with a certain percentage stake and then the remaining stake of the founders will be released to them over a specified period of time. The lock-in period can range from 3 to 5 years. The restrictions on transferability are very common in the VC term sheets. Moving on to the next slide. Just to understand what are the protective steps for the founders, what makes an airtight term sheet for the founders. Most founders feel that they can draft their term sheets on their own as they are an open source and available freely. But however, they should take advice from legal counsel as to whether the specific provisions in the term sheets offered by the investors are as per standard market practice or not. One more important point being that founders often get obsessed about the notion of control and ownership of the startup. Point is to make a wise choice between excessive dilution or under dilution. They have to make an optimal dilution. Furthermore, they have to pay special attention to the liquidation preference clause. as it might come back to bite. Further, what makes a airtight term sheet for the investors? Sometimes, because of their higher positions in the food chain, investors often get tempted for overprotection. While I think it is fair to provide the investors with multiple layer of protection, it is not fair for them to become unreasonable or unfair in the levels of economic or other rights in the garb of downside protection. Thus, there should not be patent signs of unfairness in the term sheet that they offer. So, consistently successful investors give legroom for the founders to find their way so that they can go on the growth traction path. And also, at the same time, maintaining the terms of the term sheet. So, once the term sheet has been signed and all the terms have been negotiated upon, several key documents must be drafted, negotiated, finalized before an investor will cut a check for your business. One of the key documents that we are talking about is the shareholder. This is the next part of the presentation, which emphasizes on shareholders agreement. A shareholder agreement essentially is the internal management framework of the company to effectively protect the overall interest of the shareholding by setting their rights and obligations. So before we understand the various clauses of the shareholder agreement, let us understand the legal standard. So the AOA, the Articles of Association together with the Memorandum of Association comprise the constitutional documents of the company. Thus, along with the company, they bind all the shareholders of the company by the Section 10 of the Companies Act 2013. Investors need to be aware while the shareholding agreement provisions keep changing to keep abreast of the change in shareholding or shareholders. The step changes are not always reflected in the AOA, which they may cloud their judgment and be their detriment. Thus, meaning to say that shareholding provisions cannot be contrary to the Companies Act 2013. If they are contrary, they may be void, ab initio. Let us understand the relation of shareholder agreements and articles of association in depth. I have bifurcated this into public company and private company. So for public companies, the clauses of shareholding agreement shall be treated as valid and enforceable as per Section 58.2. Section 58.2 defines what is a freely transferable security, and as long as the clauses are in compliance with the law and are not contrary to articles of association, they hold valid. However, for private company, there is no Section 58.2. So in the event the company is not a party to the agreement, the same shall not be enforceable against the company, and the clauses of articles of association shall prevail in all matters. In the event the company is a party to the shareholding agreement, the clauses in shareholding agreement are not conflicting with articles, shareholding agreement will prevail. Thus, articles of association is a charter document and is considered to be the Bible of the company and shall prevail over any agreement. In order to enforce shareholding agreements, an endeavor should be made to simultaneously incorporate all the changes in the articles of company which are made in shareholder agreements. Let us understand the structure of the shareholder agreements. We'll just quickly run through the structure, as these are the important clauses. Some of them have important clauses. Otherwise, it's a general structure. The structure lists out, the format lists out the partner to the agreement, the names, the titles, the ownership of the shares, the number of shares, the percentage of the share, the background, rationale, and the spirit of this agreement, which defines the principles between the partners and the related measures and responsibilities amongst them. Then there is general commitments, which specifies the partners' main task and responsibility, if they have an incentive plan in place, ESOPs in place. Then there's important clause that is proceedings. Generally, there's By default, each partner can freely vote in a shareholding meeting. The purpose is to ascertain that the partners will be unified, acting as a single group, even in the situations where there would be other shareholders in the company than the partners alone. These decisions basically consist of decreasing the share capital, issuing new shares, issuing convertible papers, selling all major part of the business, authorizing board to make the decisions listed above. Moving on to competition restriction clause. Essentially, the founder cannot be in direct or indirect competition with the company itself. Thus, there's a competition restriction clause in place, and there's a penalty for the breach on each such a violation. There's a buyback. There's a buyback option in a normal partner exit situation or a share disposal restriction, which we'll be discussing in the upcoming slides. There's an exit, which can happen in case of a liquidation event as well. Thus, the net consideration shall be distributed pro rata amongst all the shareholders. There will be abnormal exit situation, abnormal exit situations. There will be compulsory transfer clauses that are included in the shareholders agreement or articles to ensure that on departure, the leaving director or employee must transfer his share for an agreed value back to the other shareholders or back to the company. Rules governing share dispute. We will discuss a drag along and tag along clauses in detail in the upcoming slides. Of course, market value, if all the transactions should be carried out at arm's length basis. Thus, there should be a market value determination of all the transactions. Then point number 12, disclaimer and order of interpretation. It deals with basically this agreement supersedes all the above mentioned agreements that are signed between all the partners and the shareholders. Other shareholder agreement. It is common that the investors have other competitive restriction clauses, and they have their investors in other entities and startups as well. Thus, they have to disclose all such facts and matters. Point number 14, insight and confidentiality. It deals with disclosure of confidential information. Other clauses in shareholding agreements. There should be communication among partners. Generally, it is ideal that it should be in writing. What is the cost that should be allocated and borne by each partner, shareholder? Disputes and governing law. Disputes or governing law are governed and construed as per the law, and any dispute out of this agreement shall be resolved in the specific manner or by the specific court or by arbitration. The same shall be mentioned in the shareholding agreement. Further, agreement becomes effective upon the signature by all the partners and shall be binding on each partner as long as the partner is the owner of the share or other equity securities. Point number 90. No waiver of any term, provisions, or conditions of this agreement unless such waiver is evidenced in writing and signed by the waiving parties. We've just overseen the basic general clauses that are there in the shareholding agreement. Let us move on. So every company is different. Every dispute is distinct. There are some classic cases of disagreements among the shareholders. So to name a few, a capital versus sweat investment. Many ventures are launched with one partner providing the seed capital and one investing sweat equity. Over time, as business stabilizes and grows, the financially investing partner may wish to see a healthy return, while the working partner may come to feel that it is time and his efforts has really established the company, therefore deserving greater compensation or controlling over corporate affairs. This is one of the bones of contention among the shareholders. The next point being investment versus divestment. For example, there can be a life emergency scenario, while another shareholder might look for the long horizon and keen on growth. The other shareholder would want to uh, depart from the scene and fold. This can again lead to a conflict. The next point is a reiteration of the second point, retirement or departure. And if one so if one partner wishes to depart the venture, but no provisions has been made to buy him out, then he may see no other option but to dismantle the company, thus putting the entire burden on them. Trust breakdown. This is fairly common in the context of the news that we've been witnessing these days. The parties may suspect that they are no longer working towards a common goal, or even purposely working towards, or even purposely working against each other. Questions of transparency and the reliability of the financial and other corporate information can become a matter of sharp dispute. These are some of the classic cases for disagreement, amongst all the others. Thus, it is important to have strongly drafted covenants, which are overseen by legal counsel and are as per the standard market practice. Moving on to the next slide. So, interested investors, if an additional round of financing is carried out by the company, are protected through presence of various clauses in the shareholder agreement executed between the company, the investors, and the promoter of the company. As they say, as the money comes on the table, the intention of all the parties are subject to change. So, moving on to the various clauses that protect the founders and the investors. The governance and management body of the startup. It's a very important clause in the shareholder agreement. Board seats have to be given to access information and to the management team of the startup so that they can adequately monitor and evaluate the metrics and the results. Provision for reinforced majority in relation to the adoption of certain resolution at certain meetings must be there. It is essential that both the listed reinforced majorities for the approval of shareholders meeting and the matter reserved for the board of directors are drafted with the intention of protecting the fund and at the same time avoiding the creation of a deadlock situation. I'll just give a minute to read for everyone to read as well. Moving on to the next one. Restrictions on share transfer. The essence being the founders don't sell their shareholding before a specified period and they meet their milestones. Funds usually provide not only the founders may not transfer their shareholding, but also they engage in the business and comply with the milestone with the dedication and diligence of reasonable and prudent businessmen, devoting appropriate time and regulating the adoption of necessary measures for the proper management and control of the startup. This will be elaborated further in the upcoming classes. These are very important clauses. So, to start with, drag along right and tag along. Drag along right is basically for the majority investor, thereby meaning in a sale of a company, majority drag the minority to sell the shares at the same terms and conditions. Thus, this clause is an agreement that enables the majority to force the minority to join in the sale of the company. And the price for which will be at the same terms and conditions for the majority, as of the majority. For this clause to be triggered, it is important that proper process for the documentation and communication through formal chain is followed. Otherwise, the same will be rendered void. tag along, as drag along was for the majority of the majority investor, tag along is for the minority. This clause is framed in keeping the minority investor in consideration. Example, if the minority investors are selling their stake, the minority investors can exercise this clause to sell along with the majority at the same terms and conditions, as they don't want to be left out of the sale. Usually, this makes the negotiations and the sale a very difficult process. It is important to understand that majority can be defined as a simple majority, that being more than 50%, or supermajority, that being more than 75%. In the glossary list of the shareholder agreement, the same should be defined. Moving on to the other important clause, anti-dilution clause. Usually, implementation of anti-dilution protection is a complex process considering the existing laws. There are two types of anti-dilution: preemptive rights and anti-dilution protection. So let us understand this further. Preemptive rights. Preemptive rights are rights that are granted to the current shareholders to buy additional shares of the company in future. The shareholders have the option or the choice to purchase additional shares in the future, and they're not obligated. So thus they are of preserving value and they give voting rights. Let us take an example to understand this. Suppose a company ABC Private Limited has issued 1,000 shares to 5 shareholders, that is 200 shares each, giving them 20% ownership. If they issue extra 1,000 shares, thus every shareholder's value will be diluted down to 10%. In order to retain their stock ownership to 20%, they can exercise preemptive rights. Thus, the shareholders will have the option to buy 200 additional shares out of the 1,000 new securities that are going to be issued. So they maintain their 20% stake in the business. This is a very important clause and often exercised by the founders or the CPE investors. Moving on to the another subpart of the anti-dilution clause is anti-dilution protection. These are rights that are given to the shareholders and the investors to protect them from further dilution, thereby meaning that the protection is given to the existing investors of the company when new shares are issued in the subsequent round at a price per share which is lower than the price paid by the existing investor. If they have, let us take an example to understand this. Let us assume that CPE investor has invested 10 crores in the company for 20% by subscribing 10 lakh shares of the total 50 lakh shares. It implies the value of the share is 100. Now, if a CPE investor comes to purchase, they cannot buy the pre-money value of that share cannot be at a price which is less than 100. It cannot be 90 or even 99. If it is less than 100, then the CPE investors will have to compensate the CPE investor from any dilution by issuing them additional shares. Anti-dilution rights are very complex to exercise in India, and it's still taking shape in terms of judgments and being inscribed in all the laws and regulations. I'll just take a moment for everyone to read the example. Moving on. Preferential liquidation scenario. As we have discussed earlier, this clause protects the fund and ensures that if startup is dissolved or liquidated, at least the initial amount of investment by the investor is returned. Thus, as discussed earlier, it can be structured in a form of 1x return, 1x plus a high IRR, a 2x return, or a 2x plus IRR. Again, this is called a downside protection or a principal protection clause. The founders and the investors should give a lot of relevance to this clause while drafting the shareholder agreement as well. Let us move on to, again, an important clause, rights of the first refusal. So before I try to explain this, let me give an example. A real life case study. The minority, which we've witnessed recently, the minority shareholder, that is Shapurji Palanji, tried to pledge their shares in Tata Sons to raise funds to address their financial situation and therefore approached the Tata Sons board. Who will take such decisions? Tata Sons enforced the right of first refusal clause, which makes it clear that Tatas have balls in their court. So, just to extrapolate this, if a person is trying to sell or pledge their shares to a third party, then the shareholders using the rights for first refusal can either stop the transaction or can buy the shares before they are offered to the outside party. The main goal of the provision is to allow the investors to prevent ownership dilution as the company raises additional capital. So, in this example, as we've witnessed, by stringing the Shapurji Palanji group along, even after the dismissal of Mr. Cyrus Mystery, reminds one of the famous Eagle songs from Hotel California that you can check out anytime you like, but you can never leave. So, using this clause, it makes it difficult for the shareholder who's willing to leave to sell to a third party. Deadlock provision. This there can be a lot of disagreements between all the founders or the investors or the CDAB investors. So disagreements essentially in decision not being taken. We look at different types of deadlock mechanisms also later on if we have time. Moving on, shareholders should consider what they have to incorporate in the shareholding agreement and agree upfront at the time of drafting the shareholder agreement if and how can any deadlock be resolved. Shareholders may even get creative and come out with a hybrid mechanism or modified mechanism that they agree best manages a future impasse between them. Thus, to summarize, the essential purpose of the shareholding agreement is to make provisions for the proper and effective internal management of the company. It can visualize the best interest of the company on diverse issues and can also find different ways, not only for the best interest of the shareholders, but also for the company. Thus, I'd like to end with a quote by Henry Ford that remains relevant in today's context, also in the context of shareholding agreements, that coming together is a beginning, staying together is progress, and working together is success. Thus, a properly drafted shareholding agreement is one of the key ingredients for success, and that binds the shareholders and company as a whole to go in the common direction. Thank you. I'll be happy to take any further questions, and I hope it was insightful and I could share something new.
Yes, absolutely. I'll just check the Q&A part. I think we are receiving some questions.
Yeah.
So, thank you, Abhishek, for the presentation. There are a few things which I would like to add on. The shareholder agreement has many important facets. and which has been sort of presented. And each facet uh, is applicable at different stages of the company. And it is, it's a never ending process in a way, because even let me go to one extent of telling that when the company is even 30 years old, the next gen of the company also comes in to play. The shareholder agreement extends to even the family to a great extent. So you are seeing family disputes, many family disputes, and this is primarily because there is no clarity left by the founders at some stage or the other. So I think it's a continuous process, and even there is a regulation change. Even in SEBI, there is something called as an exemption given for transfer of share to the family members through a trust. So there are many facets to it. So that's one thing that I would like to just comment before we take on questions. So Abhishek will be happy to do that. But my view is, shareholders is not about founders. Founders become promoters actually at some stage, because by definition in SEBI, if there is a definition of promoter group. So promoter group becomes very, very important. So as one gets listed, or even at any point of time after listing, it is a very important aspect that needs to be understood. So that is what I have to state. That the shareholder agreement is a perpetuity. It actually lays down the foundation, and even it goes right after listing into the next generation also. And if it is properly done, it can become a strong fabric for the company. That's all I have to say.
Great, great. I think this has been very insightful, and I am receiving some questions. It's also inclusive of the 2 3 sessions, like a complete masterclass 4 days. So there might be some general questions also. So this one's by CA Rakesh Takyar and by Abhijit, sorry. And how to find angel investors. I think this is more from the class one
Okay.
and two.
Okay, sure.
Yeah. This is
Uh,
more from the class one and two. I
sure,
think
sure.
probably there
Yes.
are
No,
some.
happy to answer. Happy to answer. I think I'll take Sir's view first, and then I will proceed.
So you're mute. So you're mute, Ravi sir.
Yeah. So I am in a hotel. I'm trying to adjust a camera. I'm outside. So just give me a minute, Abhishek. You can. Yeah.
Sure,
Just I'm
sure.
adjusting the camera.
It's a case of thank you for the question, and it's a case of drawing both parties, right? So the angel investors are attracted by the business model, and what are the value added services that even the angel investors can provide to the startup. So it's a match of minds, and how they both can take the company forward. As far as finding angel investors grow, there are a lot of venture capitalist firms and uh, PEs. So it can be tapped through a no network, or or through a lot of pitches that we can give on different pitch book sites, etc., or going through a lot of seminars for startups. So that is a good starting point to find angel investors.
And there is a list also of available with regulators also. You can get a database from the regulators here and there, because the funding happens and the regulator is quite aware of it. So I think even that's one thing we can find out. There are incubators like NSC and BSc especially has an incubator. Again, there is a database available there. So there are various formal and informal ways of getting the uh, data and angel investment.
Yeah. This one's by CA Supraja. And the question is, how effective has arbitration been in resolving issues that you have come across so far? Would you recommend arbitration as a mandatory clause in SHA?
So I will take this because I have done a lot of arbitration, and I can tell you it's a very prudent step. Why should we go to the court of law straight away? And see, and nowadays, if you look at, there are mediation is being encouraged. Because why? Because why should we take the dispute out? We should mediate. There should be methods of mediation also. And if there is a dispute, the arbitrator should be of confidence. You can have 2 and 3 arbitrators. I think it's a great step to have a clause. It's a because it's like a protective wall, in the sense you first go there, take the arbitration. If it doesn't work, then there is always the rule of the court, or the court will come into play. Legal notices will come into play. But arbitration is the first step, and it should have a clause. That's my view. Abhishek's view we can give.
I think Sir has pitched it perfectly. So in a deadlock situation, it is important that instead of going to the court of law and hiring a lot of expensive lawyers, it's better to have a clause which states regarding the arbitration and the country in which the arbitration will also take place, because there may be cases where there are foreign investors. So the foreign laws will be applicable. So it is important all that is put in writing in the shareholder agreement.
Great. Next we have by CA Puneet Khanna. Can a deed of adherence be executed for new investor coming in on a later date for the same round?
Sorry, is it possible to repeat the question?
Yeah, absolutely. Can a deed of adherence be executed for new investor coming in on a later date for the same round? Maybe the question.
Abhishek, will you take it?
Yeah, sorry. So, yes, if the deed of adherence can be, if inscribed in the shareholder agreement, it can be done. Usually, it is not the process, but then they have to. Then there's a time value for money. Suppose if they have not been able to, if they come after 6 months, and the founders have already put the capital, so it's a time value of money, and the concept of equalization comes into play. Yes, there are provisions in shareholder agreement where investors can come at a later date. That's also possible, but they come at a higher cost than the initial investors. And then also in the shareholding clause, there is a section in which the founders can waive the extra cost. It can be in terms of increase in the principal amount or an additional interest that is to be charged to come in, say, 6 or 1 year later, depending on the time value of money. It can be waived if it is as per the discretion of the founders. But the same has to be mentioned in the shareholding agreement process.
Okay, great. Now, the next question is by CA Anil. And he asks that while there would be a lock-in period for preference allotments of equity shares, how the same would be handled post lock-in? Will there be any requirement of special or separate agreement to be entered into the deal with such transfers of shares?
Yes, thank you for the question. It's a very important question. And so post after the lock-in period expires, then there's already the shareholder agreement will be mentioning of the same, the actions that are attributable to all the shareholders or the founders. So without amending the constitutional documents or the shareholder agreement, they can freely transact either to buy additional shares or to sell their stake.
Okay. So the next question is by C. Anil. He adds on to a question and asks that regarding the board seats, will there be distinctions in treatment between independent directors non-executive directors? If so, please explain the difference.
So board seats, independent board members have a definitive agreement in the Companies Act and LODR guidelines too. Whereas executive board members have another role, which is operative role. And if an executive board member is representing a major shareholder, so their role becomes very different. So what happens? It depends on how the company has formed its shareholders agreement. What is the board constitution? Independent director's role is only limited to the board, to the audit committee, to, to the financials of the company, and also to look at the governance aspect. Whereas the operative part, running the company, that is the duty of the full-time people and people who are non-executive independent directors or executive independent directors.
Right, right. The next question is, can you please explain in basic the difference between shareholder agreement and term sheet? The difference between SHE or term sheet.
Yes. First, term sheet is basically all the informal discussions that have taken place with the angel investor and the startup. So that becomes codified, and these informal communication are put in paper. Basically, the term sheet will contain of all the will identify all the investors, the founders, the pre-money valuation, and the special terms and conditions. Example like affirmative vote, etc. And the term sheet is signed before money is invested into the company. So it is signed between the founder and the investor. A shareholder agreement, as the name suggests, it's signed between the shareholders. Once the term sheet is agreed upon, the investor cuts the check. Then the potential investor becomes a shareholder. So the agreement between the shareholders, it's a shareholder agreement, which outlines the rights and obligation of all the shareholders and the code of conduct with regards code of conduct, and also how they will run the operations of the company.
Nice. Next we have by CA Puneet Khanna. Can there be a single SHA for equity?
Can there be a single shareholder
agreement for equity?
Yes, there can be a single, but sorry, just to rephrase, is it single in sense of usually there are two or more parties involved? So just to understand the question properly.
And the question is limited. I think maybe he'll rephrase it, what he actually means by single.
Sure.
Yeah.
So if it's a full proprietorship, because there's a single investor, there will not be any shareholder agreement till another shareholder comes in.
Right, sir.
I think if Mr. Puneet, CA Puneet can rephrase it, will be better.
Yeah.
Thank you.
This one's by CA Shobha Verma. Could you please give some examples from your real life practice where investors have gone to court of law for violation of agreement by founders?
Yes, sure. One of the most recent being Tata Sons and Shapoorji Pallonji. Shapoorji Pallonji owns 18% stake in Tata Sons. So by being 18%, they are a minority shareholder. Shapoorji Pallonji's financial situation was really grave. One of the reasons being the pandemic, etc. So they decided to sell their stake. Rather than selling, also they decided to pledge their shares and get convertible debentures. So they couldn't sell, but Tata Sons, but because of the right of first refusal clause that was drafted in the shareholder agreement, the actions of Shapoorji Pallonji fell short. So they triggered the right of agreement clause, and by which they were unable to sell their stake. And the same went to Supreme Court also, and Supreme Court judgment also mentioned the same. So Article 75 of the Articles of Association also states that, as this is an internal framework of the company as well.
Another example is Indigo itself, where both of them went to SAT, first to SEBI and then to SAT and to the courts. So there, both the stakeholders went. So it just got settled a few days ago. That I'm not sure how well it has been settled, but
Okay.
there are issues. There are many such examples in public domain where they have
Great.
been.
Thank you. Next, we have from Chennai. The question is when foreign institutional investors, FII, are aggregated during an IPO situation, how these FIIs are handled if the IPO bounces per chance dispute underwriting done, despite the underwriting done.
Okay. Sorry, can you repeat the question? I'd like to hear it.
So when the FII, foreign
Mhm.
institutions, are aggregated during an IPO situation,
Mhm.
how these FIIs are handled if IPO bounces despite the underwriting.
Okay. So this essentially this is pre-IPO and or M&A transaction that is again mentioned in the shareholding agreement. So there are milestones that are covered that the founder has to abide by and has to meet, or the timelines. So it can be in the form of spreading out the business operations, or it can be in this form of meeting a specific percentage of a return. So as far as this is pre-IPO, and as the IPO goes, and if there's an IPO bounce, or by bounce it can plummet, or also it can soar. So in both ways, there's a concept called anchor investor. They have to stay whatever irrespective of the situation. Rest of the FIIs, they are free to either buy more shares on say, or if it plummets, and or exit from the same.
So just to add to what Abhishek said, suppose an IPO fails in some way, the underwriters have certain responsibility. Underwriters have to step in and take that responsibility of that company, because they have underwritten that whole issue. So to the extent they have underwritten. So, and if they are not locked in shares or whatever by the anchor investor at some stage, means, or if it's not locked in, then it's a free market. If it after listing they can do whatever. But the point that I'm making is underwriters are responsible in case the IPO is underwritten.
Okay, thank you. Next, we have a question from Vandana Rastogi, CA Vandana. When cash is getting burnt faster by the management and investors need to keep pumping money to keep the company going, which clause can protect the investor?
So there's an anti-dilution clause that can protect the investors if they want to issue additional shares. And in the case of cash burn, then it's about the operational framework. Then there are the clause regarding, there's already clause regarding the board seats, where they'll be overseeing all the management and the processes. So along with preemptive rights, anti-dilution clauses will be protecting the investors.
So just to add to what Abhishek said, every company, every startup, when there are investors, there is a weekly, monthly, bi-monthly, whatever, depending on whatever that is. There will be a cash flow statement, there will be a budget, and there will be actual. And and if it transgresses in any form, the actual burn actually becomes higher than the anticipated burn, cash burn, then the board members and the team get together, they escalate it upwards and try to find a solution, and try to adhere to a plan. So there will be a modified plan, if at all, if they all agree to revise it if there is a unusual situation. If the cash burn is due to some other reason, then it is a different issue altogether. If it's an operational reason, they may get together and try to overcome this unforeseen. For example, COVID could have been one situation where the cash burn, people who were hired, you cannot release them. Now you want to work, but your operations are hampered. So what happens? You retain them, so the cash burns could be in exceptional conditions too. So all the promoters and everybody, the investors, come together, the founders, and find a solution to that.
Just to add to that, Shreya, in fact, if investors are planning to exit because of the cash burn that has happened in Tiny Owl or Housing.com, then they can trigger the liquidation preference clause. That is, they can get their money back at a 1x return or a guaranteed IRR.
Right. Now we have a question by CA Karan. VCs or angel investors do not take a board seat in startups. They funded as non-executive director or nominee director, like banks do in most large companies, where heavily funded to keep a check on the actions. Most of the startups are private limited in structure. So your opinion on the same?
So here there are three mechanisms. One can give a board seat, one can be an invitee. And in some situation, there can be a CFO imposed on them. So it all depends on what structure they have agreed between themselves. So whether an invitee can be also as effective as a board member, because invitee to the board can throw the questions to the shareholder, to tell the stakeholder, at least give them a warning of what is happening or the good things that have happened. Board seat is another one step forward, but people are preferring invitee because I'll tell you the reason. There may be situation where you may not pay TDS or PF or something like that, and the investor nominee should not be at any sort of a problem. They're just ring fencing for that purpose. They're just ring fencing themselves. And if they feel comfortable after a certain stage, they may come into the board. So it is all very situationally driven. I hope I have answered it.
Yes, absolutely. So the question is that the shareholder agreement, who can make these agreements? Can CA make these agreements?
Basically, these agreements can be made by a chartered accountant. Usually, it is made by a lawyer, and yes, these are made by lawyers, and they are notarized and registered with the registrar, with the local magistrate.
So this being a very senior person in the profession, I can tell you chartered accountants can do it, provided they are into it, provided they know the subject and they are capable of it. Because with experience, you can make anything. You can make an agreement and all that. And registration is also not a big process. Chartered accountant can also tie up with a lawyer to do this also. It's possible. So there are many combinations that are possible. So, but one thing that I want to emphasize, and I want to make it very clear, a chartered accountant's commercial sense is different than that of a lawyer. The skill sets are different. Sometimes an agreement can be so tight that you cannot operate well. So operational freedom and agreement, and yet safety. These are three important measures one must take. And this should be a combination of that. And a chartered accountant surely has that capability.
This is by CA Vishal. Hi. So my question to CA Ravi sir, I have an idea, but I am having zero knowledge, zero capital. Can I be listed in share market at the beginning of the company?
So, very interesting question. Idea has to convert into a business model. You have an idea, it's great, but you must collaborate with somebody to put in capital. Because if there is no capital, your idea cannot be converted into a business model. And can it be listed? No, it cannot be listed like that. There is an SME platform, and there is also a listing of startups that has been allowed by SEBI. But that comes after some bit of get some gravity into the whole business model.
Okay, thank you. I think, yeah, CA Puneet, he has updated his question, and he's asking that can that single SHA incorporate different rights for equity?
Different rights for equity.
Mm.
Sure. So, shareholding agreement can incorporate different rights for equity, but they should not be contradictory to, as long as they're not contradictory to each other or the provisions of the Company Act or the articles or the memorandum. So, for different investors or founders, there can be special rights allotted to them. But in most of the shareholder agreements, the founders or the investors or the set of different investors, for them to go on a common goal, there should not be any discrimination on basis of specific rights being provided. Then everything will be at the discretion of specific investors and will lead to biasness. So there's a general framework for all the shareholders in a shareholding agreement. That is the generally seen pattern. However, legally, yes, one can, but without contradicting or having a waiver in the subclause.
Right, right. Next, we have a question by CA Anil Madhavan, that who are all called as angel investors? Is there a specific definition or a general terminology? And what responsibilities do these angel investors have to undergo?
Sure. Yes, there's a difference. If we can coin, we always coin angel VCPs together, but there's a difference in all the terms. Angel investors are those who fund usually within the first, as the company incorporates and within the first 2 years, if I can say the timeline. And when the business is just started, that's when the angel investor steps in. Other venture capitalists and Series A, Series B, Series C investors step in at a later stage when they have started taking the growth traction and there's a viable business model in place. Also, in regards to angel investors, it can be also in the form of accelerators who will take a small stake in the company for providing guidance. So we can also call them angel investors.
Okay. So there's no specific definition. I think it's general terminology.
It's a general terminology. Even the years, the period is very general and vague. So if I want to put it, it's for when an SME, for an SME segment, or for a startup. When a startup is there, then who are bootstrapped. So once angel investor comes in, that's what they call.
Right. Okay. This one's by CA Supraja Natranjan. Is it justifiable to assume that the valuation of a company will always be more than earlier valuation? In such cases, the startup may also not be able to give the guaranteed return of, say, 1x or 2x. Are there any clauses you would recommend that can protect the existing investors?
Yes, it is not necessarily that startups will give a return, and also they may run out of funds because of cash burn or operational instability or fighting between the founders. Not necessarily. It all depends on the business model and the know-how of the founders and the investors and meeting of minds, I would say. In order to protect the investors who've come in, liquidation preference clause is the best protection that can be given, which can guarantee the principal back. So it's also called a principal protection clause or a downside clause if the startup is on the verge of a failure, so they can liquidate and exit with their capital.
Okay, great. Next, we have a question by CA CD Gagrani. When a new shareholder comes in, whether the existing agreement extinguishes and a new agreement has to be entered or an addenda to it?
So it's a new agreement that has to be signed rather than an addendum to it. Further, it is also important that the articles in the memorandum, the constitutional documents of the company are amended to incorporate the necessary changes, so that they're not contradictory, or the constitutional documents don't supersede the shareholder agreement. Further, it is important to remember that shareholder agreement is an internal document, and as long as it is in tandem with the constitutional documents, it will be valid.
Okay. Next, we have a question by CA Karan. SEBI recently issued a draft paper on considering founders out of promoters group. What is your opinion on how this positive changes it for angel investors, VCs? The draft paper. Yeah.
So, sorry, to reiterate, is it founders out of the promoter group? I couldn't get the question. Is it possible to?
Should I repeat the question?
Yes.
Yeah. So SEBI, he has issued a draft paper on considering founders out of promoters group. Yes. So what is your opinion?
Founders out of the promoters group. Okay. So, as sir had mentioned before, that founders are a term associated with the startups and with the private equity, private entities, and promoters are usually when a lot of investors to come into place, and it's before the IPO and after the IPO. So that's a difference in the term.
Okay.
So because of takeover code to everything, the definition of promoter is very tight, is very clear. So because you have the creeping acquisition and takeover code that happens. So, and anybody who goes away from the promoter and does this creeping acquisition. So that is why the definition has been held on very in a very definitive manner.
Right. Next, we have question. Your views on affirmative views towards boosting of the startups in India as per the recent budget 2022.
So the budget made an announcement regarding extending of the startup timeline, which is fantastic, as the startups get a lot of benefit. They don't have to have a history if they are applying for government tenders. They can be a freshly incorporated startup. 80% of the fees waived off in terms of filing a patent, and 50% for a trademark. Then they get a 3-year tax holiday out of 10. So with this budget, the same has been extended to the upcoming startups. It is very clear that the policy making is giving a lot of leeway for new startups and innovation to come into play. The important thing is to keep in mind is the definition of startup is a very exhaustive one, but it has to do something with invention or innovation. So as long as those two matters are being inclined to, so they fall in that definition. It has to be something to do with that.
Right. Next, we have a question by CA Shobha Verma. VCAs are generally taught to look at what can go wrong while investing in a company. But if you want to invest in a startup, you have to overcome this thought process. So my question is, how can the CAs overcome this kind of mindset? If you can suggest some steps, some measures.
So just to make it clear, CAs are risk managers. Actually, they mitigate risks. And when entrepreneurship is a very different thing. Entrepreneurship comes out of your own passion. One thing that I will tell you, only passion can overcome fear. If one is passionate, so there is no substitute for passion. If you are passionate, you will overcome fear. But being a chartered accountant, You can also manage your risks. You're passionate, but you want to manage your risks. You see what the risks are, and yet you, with a calculated method, you go and take the risk. So, just to illustrate, there are chartered accountants who have started practice. There are chartered accountants who have gone into new lines 15, 20 years ago, means into, say, IT and various other segments which were not very popular those days. But they have taken the risk and have migrated. Some chartered accountants have become lawyers and chartered accountants. So, and some have joined the industry. So it's a very trait within the person. But one thing, and the most important thing, is passion and motivation. These are two very, very important aspects if you have to follow your path. So it is not about being a chartered accountant or not being a chartered accountant. There are chartered accountants in the stock market who take risk also. So it is not that. It is your own mindset, your own goal, your own passion, and the spirit in which you do your and complete your objective. It's a more of a philosophical talk that I did instead of a sort of a bookish talk.
Yeah, I think that was needed because she wanted to know how to change the mindset.
Yeah.
To add to this, actually, venture capitalists understand the market, that they know only 1 out of 10 startups will flourish, and the money that they've invested for that other 9 startups will be, they'll be able to get it back through that one startup, which will probably give them 150% return or a 100%, 1x, 100x return that covers for the capital loss for the other 9 startups. So this is how venture capitalists' thought process are. That thus they have many layers of protection clauses in their shareholder agreements. The venture capitalists usually bulldoze these terms into the startup into the shareholder agreement. Yes, most of the successful venture capitalists allow the legroom, as I've mentioned. But from a chartered accountant perspective, I think yes, chartered accountants can take any role in all these transactions that are taking place. They can be venture capitalists, they can be startup entrepreneurs, or they can be helping the startup to phase and grow. So yes, and also do the valuation of if at the behest of the venture capitalist, if required.
Right. Very rightly put. I think VCs are all around the place now.
Yes. They're political people too. People in politics.
True.
So it's great.
This is the question by CA Vishal Agrawal, and he asks that is a startup eligible for benefits under both startup and MSME? I think this was very well taken also in the last session, that yes, it's beneficial for the MSME.
Both, yeah.
No, so please continue.
Okay. Yeah. So as I said earlier, it is beneficial for startup, as there are going to be a lot of waivers in terms of IPRs and tax benefits. That is 3-year tax holiday out of the 10 years. It can be any 3 years. The third being that they don't have to have prior history to apply for government tenders, which is a very, very big positive, and which has been happening. The further MSME benefits are also available to startups, to all the entities that are listing, and both can be given.
Right. So next question is by C. Chandrasekhar. And the question is, when inflation is rising, will startup be stable? Please elaborate.
It's a very interesting question. It affects the valuation of the company if the inflation rises. It affects the discounted. If we go by the discounted cash flow method, it affects the present value. So if the inflation increases, the interest rate that also rises. Thus leading to the startup being valued at a much lesser present value. So it has a cascading effect on the startup in terms of valuation. Also, in terms of general economics or unit economics, if from a manufacturing industry, inflation it does play a vital role in increasing the unit prices, which transcends further to the retailer market.
So, in order to just add up, see, it's also in which sector the startup is. Some sectors have a longer gestation period, and some have a shorter gestation period. And the break even comes in different stages, and the valuation also comes in different forms. So it's a good question, but there is no tailor-made answer to this, except yes, inflation does impact. But if the valuation is far ahead of your inflation, and you are able to overcome the cash burn and fund it properly, and the idea is good, and you are put the right business model, so I think one can beat inflation. But if inflation comes right at the start of the start of the entrepreneurship, it can be a different game altogether. So at which stage are they? It is very important. So suppose somebody was to start something in the COVID times. So there is a very unusual situation. Somebody has gone into as a startup during when the interest rates are soft, and when the inflation is down, it's a different thing altogether. So one must factor in all these in our own financials. That is imperative.
Great. Now we have CA Yogesh Bajaj, and his question goes like, can you please give your views on safe agreements, simple agreements for future equity, the terms to be included, at what stage are they issued, etc.
Okay. Just to reiterate, simple agreements
for future equity.
For future equity. Okay. So yes, it's an interesting question, and the terms and the clauses that I had also shown in the presentation, they all should be included. Just to reiterate again, it will be from the anti-dilution clauses, that is also the preemptive rights, to the anti-dilution protection rights, to the liquidation preference right, moving on to drag tagging bragging rights, holder rights, also right for first refusal and deadlock provisions. For future equity, usually startups also get convertible notes. So that also has to be taken into consideration. What will be the valuation and when that can be triggered for conversion. So these are some of the clauses that can be factored in while drafting.
So I would like to add something. An agreement is what we have agreed upon in spirit, should be put across, and having clauses to help everybody is what it is. So I must just share something with all of you. About 10 days ago, one came with an agreement. It was, the venture was hardly anything, and he came up with a 14-page agreement. And one of the founder told me, this is the first big step that I'm taking, and most difficult. I'm ready to put money, but this agreement is very steep on me. So means I'm not able to understand this agreement. So I think the point is that we must make simple agreements and add on as the business grows or the investor comes in. If there are two people, two founders, co-founders, they can have a very simple understanding, grow to a stage, then build up an agreement. You can have agreements in stages also. So because sometimes we can be lost in the agreement. Even signing an agreement may take 6 months. They may not agree with each other. So I think it's important that business and agreement both go together, and both have to be agile and simple.
Great. This is a question by C. Anirudh Vikram Agrawal. Is there any practical use case of decentralized finance in venture or angel funding yet?
Decentralized, there's a practical use case. So I might not be able to name as but yes, in terms of decentralized finance, blockchain has taken a lot of stride. If I'm not wrong, there's a Hyderabad-based company that has started using blockchain for decentralized maintaining decentralized land records uh, in Telangana. So that is one example that is one real life illustration that I'm aware of. Also, blockchain in decentralized finance. I mean, as an extended version, will be very critical as it will be peer to peer. So, thus, any changes that are made cannot be modified or rectified. So, it is visible for everyone to see that those effects. So, hence, it can be only reversed. Hence, only a reversal can be passed. So, all the mistakes, everything will be very visible for everyone if we start using blockchain. However, and blockchain is a single entry system. The financial decentralization will also be like that. However, we are using the traditional method of double entry, so it might take some time to do that. Also, we will require changes in the laws and regulations to enable this.
Right.
But yes, sorry, just to add further, decentralized finance is also seen in stock markets and stock exchanges also. It's in the derivative product segment, which is going to be coming.
Okay. Nice. Next question is by CA Preetham. And the question is, are angel investors defensive during the COVID-19 pandemic? Your viewpoint.
Yes and no. It depends on cases, and it also depends on what kind of angel investors there are. So there are angel investors because the valuation of the companies went down during COVID-19. So a lot of angel investors could put money at a very low valuation. So if a startup valued itself at 1 crore because of COVID-19, they were valuing themselves at 70, 80 lakhs. So startups, a lot of angel investors, it was an opportunity for them to invest at a very low price. So there's a lot of money flow actually into India through angel investors during this time because of the low valuation.
Okay. Okay. Different perspective, I think, than what.
Yes, different. Also, depending on the business model and again, transaction to transaction, what the startup wants to do. Usually, fintechs are getting a lot of funding, angel investor funding. Most of them based out of Bangalore and Mumbai. That is precedence that has been seen in the last 2 years in the COVID-19 scenario. However, the clauses are something different. Clauses are becoming more stricter, and the parameters are being more well defined.
And that is also primarily because there have been a lot of failures, and the investors have also lost a lot of money. So they also want to ring fence, and there are LPs behind them. So there are a set of investors behind them also. So we have to understand it's an ecosystem where money is not cheap. Everybody's money is chasing the other, and it's not easy. So everybody is looking for performance. Even the investor who is there, even marquee investors, they may have thousands of LPs behind them who will be funding them and who will expect a big return. So it is an ecosystem which is filled with totally, funding each other and seeing that there are strong agreements because people don't want their money to be wasted. They also factor in that out of so many investments they will lose money in this much. So they know it, and they know when to terminate an agreement. They know they exactly have the acumen and the skill sets, the good ones. They know this venture is not working, or this is not working. This startup is not going to work. They know when to jump off the train. And equity investors anyway, they wait They wait. If the train is moving fast, they will jump into it. If it's very slow, they will jump out of it. So it's a very situational thing.
Right, nice, very nicely put across. The next question is by CA Anil. And the question is that please throw some light on fixing IPO prices per share.
Fixing IPO prices per share. So it's a very interesting question, and so everything depends on what is the future valuation of the company. So there are a lot of valuers at work that see the business model and see the run rate, the percentage run rate of each business segment, and accordingly, along with the merchant bankers, the investment banking team, and the underwriters, the IPO prices are determined.
Okay. Taking the last 2-3 questions. So this one's by CA Falguni. Are there any guidelines available for preparing agreements pertaining to startups funding at various stages?
So yes, there are a lot of sort of basic standard guidelines that one must adhere to. So it's the shape and form of all the clauses that we've mentioned, and so in terms of guidelines, it should the most important aspect is that it should be a standard market practice. If one is filing an agreement which is not seen in the market and being advised to which is not a standard market practice, then one should not go for it and seek legal counsel. Irrespective of whether a person is from the financial or non-financial background, they should seek general legal counsel advice on drafting and following the guidelines, as they'll be much more aware of what is the standard market practice and what are the evolutions also that are taking place in terms of the industry and the legal terminologies that are being placed.
Okay. Next, we have CA Anirudh. The question is that is ESG also considered in agreement stage now that it is reported mandatory for the large companies? Environment, social, and governance.
Yes, absolutely.
Shall I take this? So ESG is a very important aspect. Especially the cost of funding may come down with ESG because there are companies and investors who are only told to invest in ESG compliant companies. So it is going to be a factor. Climate change is going to be a very big issue. And you have seen it in this budget also, PLI for solar, etc., etc. So you will see that ESG becomes a very, very important aspect. And that is one thing that needs to be considered by all the founders, all the people who are making startups. We have to take this into consideration because ESG, even electronic waste, something like an electronic waste. So things like this will come into play as we go across. ESG fund is a very important one. And it may not be necessarily be used by everybody, but it can be in some sectors, it will become very useful.
I think Sir has aptly put it. And just to include one more aspect is that the Paris Agreement that has been signed recently, also the coal reduction by 2070. So for a manufacturing base, it becomes, if they are not complying with the ESG norms, then they'll have to pay in terms of the carbon credits. So ESG has become a vital part of the documents and the traction that the green environment is showing as of the moment. There will be more clauses to it, and it will be a natural evolution in regards to that also.
Okay, thank you. I think let's take this as the second last question. And I think it's CA Vishal who's continuing, and he says that how to think as an entrepreneur for a startup in the middle of high inflation. The startup idea is automobile industry. I think his earlier question was that he just has the idea and no. Okay. I think this is an add-on to his question.
So inflation is not a a great thing anyway. And for a startup, it's not a great thing. And for a manufacturing set of thing where there is hardcore cash burn, it's a very difficult thing to have, because the interest rates will go up, and you'll have to give returns which will be higher. So I think it's not a very good thing. But I think all these things average out, and that is what is very important. You don't look at today; you look at it in 2 years perspective, 3 years perspective. Can I last the first year? Can I last the second year? Can I go? It's like a car. You put so many liters in a car, go to a next place, fill up again, and go to the next. Or it's like climbing a mountain. You climb up, look back how much you have climbed, look up how much you have to climb, and that is the way it works. All startups work that way, honestly. So inflation is just one part of it. There are other parts of it, but high inflation does impact the cost of funding. Yes, Abhishek, you had something?
No, actually, I think I just like to wish, I think, best of luck with whatever you're pursuing. And, it's a very interesting industry to be in, as there is electric vehicles that are coming into place, and automobiles are gaining traction in that, and even the auto ancillary segment. It depends where you're sourcing your raw materials from. Yes, the cost of petrol, the cost of oil, and has impacted the unit economics. Further, with the inflation which has been on the rise, has will impact the business situation. And but it all depends on a viable business model and operational implementation of the same.
Right, right. Uh, so this being our last question, can you please throw some thoughts on FEMA impact on startups when someone wishes to enlarge globally through the startup, though the startup is in India only? So the FEMA impact.
So, in regards to the basic knowledge that I have regarding FEMA, I will not be able to answer it as well as some of my peers. But with regards to FEMA, I think the foreign money transactions, inward and outward, it does play a role in terms of impact on the foreign exchange transactions. There'll be some foreign exchange loss also. So again, forward contracts will have to be signed if you're going to be trading or dealing in a regular basis, whether it is manufacturing or the service industry. So it is important to have important merchant forward contracts being signed at regular intervals. Also, the foreign currency is subject to a lot of fluctuation because of the macroeconomics. Thus, that has to be also factored in. And the regional, the political scenarios have to be considered, as some areas are unstable and some are flourishing. The market for each place is different, and so yes, those aspects have to be considered. And FEMA, of course, is guided. The parameters are defined by RBI. So all the net foreign remittances, they all have to be disclosed to RBI on a quarterly basis.
So just to add on FEMA, um, so there is FDI. There are limits on FDI, that is on inward remittance, how much one can take in each sector. For example, insurance has 74. Every sector has certain barriers to it. Okay, and you cannot cross that barrier, otherwise it becomes a violation. It becomes a violation. So we have to be cognizant of the fact that every sector has certain inward remittance barrier and outward remittance barriers, and we have to work within that barriers. And every sector is different. For example, somebody wants to buy a property outside India, there are limits set for it. So everything has a limit. If somebody wants to send money outside India For personal reasons, there is something else. If they want to set up a subsidiary outside India, there are different rules. For example, banking companies, they are not allowed. They don't get subsidiaries to be made outside India easily because there is a regulator there. So every sector is different. And for startup, just to say that the initial limits are quite sort of favorable, and I think that's an area which I think there will be little more liberal approach to that as we go forward. Uh, at this moment, there is nothing specific for in FEMA for startups, as this is for startups. For inward remittance, yes, not for outward remittance, because you go through an authorized dealer and take permission. So that is the way it works. And you have a business model, you take permission and do and invest. And there are one more thing that I must say, that the recent amendment of countries which are border countries, that also has to be taken into account, like China, etc., which was, the guidelines have been very restrictive there. So one has to take into account that also.
Great. I think with this, we come to an end to our Q&A session. Very well put forward. And I'd like to thank our speakers for the day, Ravi sir, S. Ravi sir, and Abhishek sir, for such lucid presentation, for answering all the questions in real time and explaining and bringing the fourth day to the sunset. Thank you so much. I'd also like to take the opportunity to thank the leaders of the committee, the chairperson, C.A. Dheeraj Khandelwal sir, and Vice Chairman C.A. Pramod Jain sir, for continuously bringing up initiatives in the committee for new webinars, for classes, so as to CAs like us can know more about the field, know more about startups and MSME, our roles, and how we can stand hand in hand with the world. I'd also like to thank to all the speakers for the 4 days. This has been a very enthralling and educative learning experience for us, right from the day one, from building the thesis to day 2, where it was all about how to get the deals, then day 3, valuation, and now finally it's the agreement time. I think this has been extremely beneficial to all of us. And I'd like to thank the entire secretariat of the committee, leading by the secretary, Dr. Sambit Mishra sir, for bringing this out together in such an easy way. And last but not the least, I would like to thank all the participants for their active participation all through the 4 days. I've been reading their questions. It has always been so new, different, and eager to learn and know more and more. I hope I've been able to take up all the questions, and this session, this masterclass, has been beneficial to one and all. Have a great day ahead. And once again, thank you so much. Thank you.
Thank you so much. Thank you for calling us.
Thank you.
Thank you.
Thank you.